Welcome back. I'm Vincent Perryman, and you're watching Legalese. On our show today is Patrick M. Ardis of Wolf Ardis PC. We're talking about tort reform. Before the break, we covered what tort was, kind of how the process generally works, and then what some of the reforms are that have already been put in place in Tennessee that very much put limits. And then we got into how Missouri had come to the change. And I guess the big question for me is we're already limited to, we got to bring it within a year, all of these restraints on the suits already. And we hear the politicians advertise, hey, we're pushing this tort reform, I'm for tort reform because we need this. And we've never gotten a clear answer from them. So I guess, what's some of the stuff that's being pushed right now?
Well, there's a constant push to limit the liability for a manufacturer in the great state of Tennessee. And that's not a manufacturer who's incorporated in Tennessee. That's a manufacturer who's just selling product in Tennessee like they're selling product in the other 49 states.
So they may actually not even be providing any jobs to any Tennesseans.
No, and it's what I don't understand, and perhaps what's most complex, if I can, for a moment. The concept of a tort reform is changing the law, period. And this is stuff that is ancient. This is things that have been handed down over literally thousands of years, never mind hundreds of years, tried and tested. And of course, the decisions are not by the evil lawyers, as the stereotype would be. And I might add, the stereotype is generally set by lawyers who are politicians who are making the speeches, which I don't understand either. But the truth of the matter is, at the end of the day, it's a decision to change a system that has been done and set by jurists and juries, which are people. In this case, the American public, over, of course, of a couple of hundred years plus, have made decisions on who should be responsible for injuries that are caused to an innocent party. And so the changes have been made and are being made. But one of the great assaults, as I see it, is now there are caps on the amount that a person can be entitled to. And lawyers are, like it or not, small businessmen and women. We are, in fact, a group of people who employ folks in the great state of Tennessee. We work in the state of Tennessee. Some of us are fortunate enough to work on hourly basis where we're paid by the hour. Some of us work on contingency basis. I do both. Contingency means if you were to come to me and you didn't have the money to pay for a lawyer, then I am allowed to represent you and to pay the cost of your case. Not pay you, but pay the cost of your case in order to see that justice is done, to go into a forum that is unbiased in order to try a case to see if the people from your community decide that you are entitled to relief, benefit, to be paid, to be compensated. In the great state of Tennessee now, for non-economic damages, the pain, the misery, the hurt. Envision a person who's burned on 30% of their body and are in the hospital for weeks or months at a time before they're released. That person, unless it's more than 40% of their body, is only entitled to a total cap on, quote, non-economic damages of $750,000. Economic damages, well, great. If it's a doctor or a lawyer or somebody making a fantastic salary, it could turn out to be a valuable lawsuit. But if it's the average working guy, then truth of the matter is he's not going to have a big economic loss. He's going to have all this horror from the pain that he or she went through. Any recovery is going to go to pay the medical bills first. That's the economic side, medicals. And then two, they're only going to have a limited amount they can recover on the, quote, non-economic side for pain and suffering. A major lawsuit on a product liability case, somebody for a defective product, will cost my law firm $400,000 to $500,000 to get to the courtroom. If the recovery is going to be capped so that it's not worthwhile for me to pursue or for the person to pursue, then the doors of the courthouse have been closed. And that's what we're seeing. More and more, the economic incentive to be fair is disappeared. And then the question is, who pays for the person that's damaged? If it's not the person responsible, then the question is who pays? And the answer is we do. The citizens of the great state of Tennessee will take care of their infirmed, their injured, those that are not able to work any longer, or the great United States of America will. We will again. So I don't understand tort reform. Tort reform is reforming the ability of the average person to seek relief against a large corporation. But where's the fairness? And at the end of the day, we, the people, end up paying for the wrongdoing of others in order to protect the innocent.
Yeah, and it's one of these things that I always am left scratching my head at some of the proposals I see, because I'm like, okay, I see what you're trying to do here, Senator.
Well, what are
or whatever,
you trying to do?
Well, and I think their idea is that there's a problem that exists that's not a problem. And I think it always gets tied back to the politician's argument of, oh, well, they are legislating from the bench. And that's the whole thing of, I want to say, did you not listen in U.S. government when you were in high school? I mean, that's what common law is.
Well, it's actually not from the bench. It's from the jury box.
Yeah.
It's the people in the community, directly and particularly. And in the great state of Tennessee, 12 out of 12 jurors on a state court jury deciding what justice should be. Now that is America, and that is the most basic sense of the entitlement of the people to have a limited government and to make the decisions about what is right or wrong.
And the other thing that I've never seen a politician address or be asked about was, if you look at the total number of lawsuits that actually go to trial and are tried, they're not very many in the state of Tennessee.
2%, maybe 3%. But the truth of the matter is, we'll have more trials and see more lawsuits tried if, in fact, the economic incentive to get a case resolved is gone.
Right.
Consequently, if, in fact, there's a limited amount of damages and it turns out the damages are inadequate, well, then the lawsuit won't be brought and the person will go on the welfare of the state, period. If the suit is brought and there's no incentive to settle it because the limit on damages is such, then there will be more and more cases tried. So we'll have, I believe, a greater taxing of our court system at a time of inadequate funding of the court system, backed by less people being able to go to court because there isn't any financial incentive to seek justice in a completely neutral forum.
Yeah. And when we return from our break, we'll talk more with Patrick M. Ardis of Wolf Ardis about tort reform. Please stay with us.